Those with electronic devices know what I'm about to say. You may not use them for recording or for photography, but you may use them to speak to the outside world about what you've heard in the hearing room 10 minutes after it's elapsed.
Thank you, sir. Mr. Gunn, before we move to another topic, I just want to ask you a couple of questions I neglected to in relation to the use of deceased children's identities, please. You mentioned in your evidence this morning that you were aware at the time you were Commander Operations that there had been 2 or perhaps 3 undercover police officers who had used fictional identities that weren't from deceased children's identities and who had been compromised. Without telling me what their names were, in case those officers are closed officers, do you remember who those officers were?
No, I remember the circumstances, but I do not recall the names of the individuals or their ciphers. But I am aware that it was outside of my period as Commander Ops, but I am aware that it was part of the rationale for the use of birth certificates that officers had been compromised in the past.
Were you aware of an officer, HN56, who used a fictitious identity during your period of time as Commander Operations? That was not a...
Could I see who HN56 is, please?
Yes, of course.
No, I don't recall the name.
Okay. One last question on this particular topic. I had asked you some questions about Tony Waite being aware of a disclosure from Bob Lambert about his relationship whilst he was an undercover officer, and that he hadn't reported it. In fact, his evidence to this inquiry was that he reported it above him to Mr. Tucker. That would have been the appropriate thing to do in the circumstances, to report it up his chain of command. Is that right?
Mr. Tucker, did you say?
I believe so, yes.
Pardon?
I believe so, yes. That was Mr.
Well, I don't
Waite's
recall
evidence.
that we had a chief inspector or superintendent, Tucker, in the branch, but I don't recall him being associated with the SDS, and I certainly don't recall the circumstances you just relayed about Tony Waite telling him.
Okay, I'm very grateful, thank you. Right, we will move on to another topic, please, which is arrests of undercover officers during their deployments, during the time you were Commander Operations. Just generally speaking, at the time, were you aware of the Home Office Circular number 35 of 1986, which was the consolidated circular to the police on crime and kindred matters?
Yes.
Sir, for your note, it's MPS 0727412 at page 2, tab 83 of your bundle. Paragraph 1.92 of that Home Office guidance provides that the police must never commit themselves to a course which, whether to protect an informant or otherwise, will constrain them to mislead a court in any subsequent proceedings, if his use in the way envisaged will or is likely to result in its being impossible to protect him without subsequently misleading the court. That must be regarded as a decisive reason for his not being used or not being protected. Were you aware of that at
Yes.
the time? And it further provides the prosecution should be informed of the fact and of the part that the informant took in the commission of the offence. Were you aware of that as well?
Yes.
And as far as you understood or you were concerned during your time as Commander Operations, did you consider that those directions, that guidance applied to the SDS.
Yes, but it was guidance. And if you're going to ask me a specific... Well, carry on.
No, do comment if you wish to.
I was only going to say that as far as the two occasions, I think it was two occasions on my watch, where it occurred, an officer was caught. One was drink drive and the other one was John Dines, which I can say, I think. I am aware of those two. I dealt with both of those cases in the full consideration of the guidance, in the full consideration of the interests of justice, and also in the consideration of the circumstances surrounding the incidents. And I don't know whether you're going to ask me specifically about the drunk drive, but if you are...
Yes, perhaps we can come to that in a moment. I am going to ask you about that and about John Dines, and but you'll obviously have an opportunity to say whatever you like at that time. Can I just look at what you say in your statement at paragraph 23, please, which is where you set out your understanding that the starting point was that UCOs were to avoid involvement in criminality, and that anything beyond that required consideration and authorisation by managers. Did that starting point apply irrespective of the field into which the UCO deployed?
I'm sorry, I don't understand that. Could you repeat that? Sorry.
Yes, of course. Does that starting point, that UCOs were to avoid involvement in criminality, apply across every field of deployment in the SDS?
Well, it was a part consideration in respect to the circumstances involved in each incident. I had to make a judgment as Commander Ops as to whether or not the guidance was followed to the letter or whether the guidance was followed to the spirit. On occasions, I found myself between a rock and a hard place. John Dines was a classic example of the rock and a hard place, not so the previous drunk drive. But I took the action I took in the best interests of, one, justice, two, the reputation and safety of the officer, three, the reputation of the Metropolitan Police. And I had to make a judgment.
Yes.
Because, unlike now, where the Covert Human Intelligence Source Criminal Offences Act of a couple of years ago, when it is recognised that for national security reasons that there is a possibility that undercover officers may have to commit criminal offences in the course of their undercover duties. We never had that. That came in, I think, in 2023 or maybe 4. We never had that. But I had to do and take the spirit of the recognition that sometimes you're on the edge of the law, and I was on the edge of the law, but made that decision in the full cognizance of the guidance, my judgment, against the circumstances at the time.
Okay, we'll come to those individual cases in a moment, but were you aware of an acknowledgement within the SDS itself that those targeting particularly animal rights groups would inevitably need to participate in criminal activity?
No.
Had you been, would you have taken any particular action in relation to that? Or would it still have been the same balancing exercise, cognizant of the guidance?
Exercise. I mean, in terms of priorities, we were having more trouble from animal rights extremists at that time than most others. So it would have been up the chain of priority in terms of dealing with matters, but in terms of the principle of dealing with it, staying within the spirit of the guidance and or the criminal law, it would be another part of the consideration.
Do you recall discussions you had with the security service to the effect that any undercover operations against animal rights extremist targets would be bound to involve the commission of acts of criminality in order to gain acceptance amongst the groups of hardened activists?
I don't recall that conversation, but I don't deny it took place. It's highly likely because the activities of the animal extremists were very much in terms of greater threat than just bill posting, etc., the smaller, less significant criminal offences. They included up to placing firebombs. And again, I come back to the fact, this was 30 years ago certainly. Not too many people remember the febrile atmosphere there was in this country at that time concerning animal extremism and the threat and risks that this country faced from those elements at the time. They were extraordinary circumstances, and we had to use extraordinary measures to deal with them. And animal extremism, in respect of potential for criminal offences, would have been top of the list.
And was that an acknowledged risk that those directions in that Home Office circular wouldn't be followed necessarily in those cases?
Well, I'm not sure whether it's acknowledged or what. What I'm saying is, I did not ride roughshod over that guidance, ignore it, or just assume that SDS has got special treatment. What I did was take into account the principles of the decision and the guidance, match it against the principles of the circumstances, and come to a judgment.
Yes,
and as
we'll
I
come to
said,
the case.
sometimes it's a rock and a hard place.
Yes. At paragraph 137 of your statement, you say that you believe that the SDS had a process in place to assess involvement of UCOs in criminality and that this appeared to work. What was your understanding of the process that the SDS had in place?
I'm not sure I quite understand the question. We're getting into territory here which I think is restricted in respect of how I dealt with John Dines, which was pertinent to other considerations. I need guidance as to whether or not I open that up, because I understand it was redacted from my statement.
Well, let's not go underneath a redaction, but perhaps if I can ask you to look at paragraph 138 of your statement. You say there that UCOs would inform the SDS if they were arrested. Once the DCI and DI were aware of this, they could monitor progress through the criminal justice system. A written report was prepared for the squad chief and I expected to be made aware. Is that the sort of process you were referring to?
Yes, I'm sorry, I slightly misled you on that previous answer. That was to do with a specific incident.
Not at all.
I stand by what I've said in para 138. That is the right process that we would have gone, well, right. That is the process we went through, and I support it.
And you maintain that that was an appropriate process,
yes,
even looking back today?
I do.
That process doesn't address, though, does it, anything specific about the potential for misleading the court during any type of prosecution involving a UCO or the activists they were deployed against?
It's not in black and white words, but it's implicit that the Home Office guidance applied to everybody.
And was there a recognition of the potential for miscarriages of justice? I'm not happy with the description of miscarriage of justice in the respect of this sort of incident. As I've said, we were faced with circumstances that we had to deal with according to the law as it stood at that time, and I emphasise at that time, and the circumstances of the offence. And I go back to what I said earlier this morning about the need for security of the operation in respect of the government, the Home Office and others. You say you confirm in your inquiry statement that, and you've said today, that you would expect to be informed if an undercover officer was arrested, whether in their cover or real identity, and we'll come to some specific cases in a moment. But would you also expect to be informed of a UCO's involvement in criminal activity where it didn't lead to the arrest of the UCO, but nevertheless occurred?
Probably.
And why probably? It would depend upon the circumstances.
Yes, depend on the circumstances. I mean, there's gradations of activity, culpability, and responsibility, and it would depend on the circumstances, which I would be expected to know, how I dealt with it.
And were there circumstances where an UCO would be involved in criminal activity that you would expect not to be informed?
No. If there was any indication of potential criminal offences, arrests affecting the individual undercover officer, as Commander Ops, would expect to be informed.
And what if the criminal activity in which the UCO was involved or was peripheral to led to the arrest of others but not the UCO? Would you expect to be informed in those circumstances?
Yes.
And you would clearly expect to be informed of any charges or prosecution where the UCO was involved in the activity leading to the arrests in relation to those charges and prosecution. What about if a UCO appeared as a defence witness in court? Would you expect to be informed of that?
Sorry, of what offences?
If a UCO appeared as a defence witness,
Yes.
would you expect to be informed of that?
Yes.
In your witness statement, you say that minor offences such as bill posting, and you've confirmed again that circumstances may be that committing minor criminality would be acceptable if it was operationally necessary. You say that at paragraph 139 of your statement. What sort of circumstances would make it operationally necessary?
Well, I think it's self-explanatory in what I've said in para 139. We obviously would take into account the seriousness or otherwise of the offence and post that against the circumstances posed at that time. Sometimes bill posting involved violence and unruly behaviour, which would add to the consideration as to which way to jump in terms of court appearance or not. Other times, a mere bill posting and skedaddle by the individual, if arrested for something like that, that would be then a matter of judgment that was a lesser seriousness than if there was violence.
And so, and you confirm in paragraph 140 that more serious offences committed by a UCO would not be acceptable. And what sort of offences would you have classed at the time as more serious? Something involving violence?
Offences that involved public safety, injury to others, serious criminal damage. I mean, there's a list that I can't really go through now, where the circumstances of the offence is pertinent to the decision on whether or not to follow the strict guidance of the Home Office or the spirit of the guidance of the Home Office. And I would have said where there is human injury, serious damage to property, and or threat to life, obviously, but there's a range of other offences. I mean, some of the animal liberation people that were going to harass people in Huntingdon when I was Chief Constable, Huntingdon Life Sciences, for instance, the directors of that firm were subject to the most enormous threats from animal rights demonstrators. In itself, there was no particular serious criminal offence, but the accumulation of that activity adds up to the consideration as to whether or not we would charge or not. So it's impossible today just to give a carte blanche on what offences do and what offences don't come in the range of my decision process.
In your witness statement, you reject any suggestion of a culture of turning a blind eye.
Absolutely.
And you say that any decision not to take action, that is against a UCO, had to be made by an officer of appropriate rank and properly recorded. Is that right?
Absolutely, and I think the action I took in both the cases I referred to earlier demonstrates only too well that there was no culture of turning a blind eye there. There was obvious action needed to be taken, and I took it.
Yes, we'll come to those in a moment. You mentioned, excuse me, you mentioned appropriate rank. Are you referring there to your rank and above?
If there was criminal offences involved, yes.
And what type of action? You say that any decision not to take action had to be made by an officer of appropriate rank. What type of action are you referring to there?
Where, going back to the points I've laboured this morning, where the danger of exposure of the work of the SDS and the individual, or a threat to the safety of the individual, was relevant to the decision-making process, I would take that into account. And I no doubt we'll come on to it in a minute. I'll explain why in one of the cases.
Yes. So in your inquiry witness statement, you confirmed that it was SDS policy for UCOs to give their cover details when they were arrested. It was acceptable for a UCO to give a false name along with members of their group to maintain their cover. And you explained that in relation to SDS operations, you, as Commander Operations, retained the discretion over what to disclose, to whom and when.
Yes.
Is that right? Was that standard practice as Commander of Operations throughout your time, throughout your tenure?
Well, I was Commander Operations for the 4 years that it applied when I was Commander Operations.
And did your predecessor do the same?
Sorry?
Did your predecessor do the same?
I would have followed Peter Phelan's activities, yes.
And did that equally apply to criminality where the UCO was involved but not arrested?
Yes. Well, depending on the layer of the criminality alleged.
Yes.
But mostly, if there was criminal behaviour, the threat of charges, arrest, etc. on the officer, which would implicitly endanger the SDS in terms of exposure to an open court, then yes, the Commander Ops would have to make the decision.
And you state that while operational security was very important, the interests of justice and the seriousness of the offence would have also been significant factors. That's at paragraph 143 of your statement. Was it appropriate that the interests of justice were merely a significant factor? Aren't the interests of justice a decisive factor in what action should be taken?
Well, this is where we come back to decisions at the time, weighing up the pros and cons of the incident against the guidance that we are granted, and indeed recognised by the state subsequently under the new Act of CHIS criminal behaviour. There are circumstances where it's a fact of life. Undercover officers may get caught up in the criminality and or public order issues of their colleagues. And I tried to explain earlier that undercover policing, its very essence, is deceit, deception, and subterfuge. It's unsurprising that those undercover officers give the name which would be deceitful to the criminal justice system, but which, for their compatriots and co-extremists, was essential, because they're hardly likely to turn around on PC blogs.
No. Let's look at 2 arrests of John Dines then.
Yes.
On the 6th of December 1988, John Dines was arrested during a protest involving inspection of livestock transport. He provided a false name and subsequently appeared in court under his alias. You were briefed and kept informed of that throughout. The document references MPS 0526792. It's tab 99 of your bundle, sir. And you also informed Daxo S. Phelan of his arrest. And was that reporting to Daxo S. Phelan necessary because he'd been arrested and charged with other activists who intended to plead not guilty to the offences?
Yeah, I don't recall this particular incident. I've refreshed. It was one of those in category 2 of my decision-making process. I didn't recall the circumstances of this particular arrest of John Dines. I'm referring to another one, which you no doubt come on with.
Yes, I'll come to.
But I stand by the statement, the written circumstances and decision, because it took into account what I, as Commander Ops, had to do, which was weigh up those issues, pro and con, a person, an undercover officer, being arrested, charged, possible imprisonment, possible definite exposure from an open court to the work of the SDS. So I agree with the minute, but I don't recall until I read the minutes, I didn't recall the Hereford arrest.
In your inquiry statement, you say you would have intervened had the matter proceeded to a contested trial. What in fact happened was, in the absence of any direction from you, you considered that a bind over and fine in his case, which was what the court did, in his cover name, was justifiable and proportionate.
Yes, I think the circumstances of that and the offer of a bind over or whatever would have matched the circumstances and seriousness or potential seriousness of what the person was charged with, which wasn't, in my mind, serious criminality in respect of the nature and activity surrounding that incident.
You acknowledged that the SDS managers did not declare any interest or intervene with the courts or the Crown Prosecution Service, and that it was a matter of good fortune that the prosecution offered no evidence. So the fact that John Dines was a UCO wasn't revealed to the prosecution or the court in that particular instance. Is that right?
Well, it seemed to solve itself by the circumstances, but the rationale behind that is borne out by my action of a subsequent arrest of John Dines, where, for different reasons, I took a different view, taking into account all the circumstances of the incident.
And did you discuss that with other senior officers, this case?
Well, I think it's almost inevitable. I would have discussed it with Peter Phelan. He was He was in the next room. This was a serious matter, prejudice potentially to the reputation of the police, and to the exposure, importantly again, and I keep coming back to it, of the SDS.
Was any consideration given to the consequences of non-disclosure of the fact that he was a UCO to the court, to the other arrests?
I'd like to think at the time I took that into account. I can't recall now whether I specifically did, but I certainly would have hopefully taken into account the considerations of the law as well as the considerations of the guidance.
Because the guidance would have directed that his identity should be disclosed.
Yeah, but there's no guidance in my submission can cover every eventuality of the sort of situation we were in, extraordinary situation dealing with extraordinary threats to the country. No guidance from the Home Office or anywhere else can cover every aspect of that.
No.
We have to deal with the circumstances we're faced with at the time. And sometimes, in the heat of battle, decisions are made that you might change later. On this occasion, I wouldn't have changed it.
So you didn't at the time, and you don't now, consider that the lack of disclosure to the court was problematic?
In the circumstances of the incident, no. The greater good, the greater risk of disclosure in that case, to me, didn't match the activity alleged.
And you didn't consider it problematic that there was that potential, there was a misleading of the court in that case?
Well, of course I did, because in a previous case, the drunk drive, I took action which recognised exactly that.
But in this case, your view was that misleading of the court, which I think you accept, it was misleading the court not to have informed them of his involvement as a UCO.
Yes.
That was balanced against other considerations which you've told us about at length, and that was the decision you made.
Yeah.
Was the effect on those others who were standing trial that had been in very close proximity to him in relation to this activity, in relation to which all of them had been arrested. What consideration was given to them and their proceedings?
Well, as I've said, I don't recall this specific case, so I have to rely upon the documents that I was shown and being shown now. And I can only say that the action taken, in my mind, was commensurate with the circumstances of that particular incident. But I don't recall specifically now the detail of that case.
Would consideration have been given to the effect on the other defendants who were intending to plead not guilty of the fact that John Dines, in his undercover identity, had accepted a bind-over and a fine, where the court didn't know he was a UCO?
Well, I repeat, I don't recall the circumstances of the case, but I would have hoped, and I think certainly yes, consideration would have been given to all of the aspects of the prosecution of a case where an undercover officer was involved.
And you say you considered the Home Office guidance. Do you
Yes.
accept it wasn't followed, at least to the letter, in this case?
Well, I accept that.
You also agreed to allow John Dines to accede to a request to be interviewed by a chief superintendent from West Mercia Police, following an official complaint made by the activists. So for your note, it's MPS 0526792, page 4 at minute 6. In your inquiry statement, you state that the only viable option for John Dines to maintain his cover was to go along to that interview. Were other options considered?
I don't recall that case. I'm sorry, Mrs. Simcock. I do not recall the detail of that case. I can only rely upon the circumstances as described in the minutes taken. I don't demur from the decisions taken at the time, but I don't recall the specific incidents of that case.
In relation to there being no other viable option for him to maintain his cover, allowing him to go to that interview, wasn't there an option to bring the chief superintendent from West Mercia Police into the confidence that he was a UCO, and that was the context of him appearing with those activists in that incident?
That was an option, but again, that would have to be part of the consideration of the risk of exposing the work of the SDS through the behaviour of John Dines on that particular occasion. And it's a reasonable assumption that somebody should ask the chief superintendent to attend, but at the time, I suppose the decision was taken in the best possible interest that was too risky. I don't know. I can't remember again.
Okay. Let's move on then to the second arrest, which was on the 31st of March 1990. John Dines was arrested at a poll tax demonstration for being involved in assaults on uniformed police officers, and he was charged in his cover name of Wayne Cadogan.
Yes.
With threatening violent disorder contrary to Section 4 of the Public Order Act 1986.
Yes.
Would you class that sort of level of charge as a serious offence?
Yes.
You, with the approval of Daxo S. Phelan, instructed him to effectively skip bail, to not attend court on the 10th of April 1990 when he was due to appear. Despite his earlier stated intention to attend and plead to the offence.
Right. Let me give you the context and a proportional response to that question. John Dines was likely, if convicted, to suffer imprisonment for that offence. As far as the offence was concerned, it was obviously serious. We were going to prejudice, possibly, the interests of justice, whichever course of action we took. If John Dines had been allowed to go to court in his cover name, that's misleading the court. If John Dines skipped bail, that's misleading the court. But the lesser of those two evils, given into account all of the issues we had to consider, and I keep coming back to the range of issues that we had to consider in these circumstances, the lesser of those two evils, in my judgment, was he skipped bail. So there was an implicit interference with justice on that occasion, but not as implicit as putting him before the court and going through a whole trial with duff details. I'm sorry, I still stand by, given the circumstances we were under, and I keep mentioning a rock and a hard place, sometimes you have to make decisions which in the cold light of today may not appear justified. Well, so be it.
You also facilitated cancellation of the outstanding warrants against him through Detective Chief Superintendent Ram. And again, was the reasoning behind that decision and instruction the best balance between those competing factors that you were talking about?
No, on this specific point, I need guidance, because the rationale of what I did following the decision for John Dines to skip bail
restricted,
as redacted. But the incident or the circumstances that I described in that redacted part of my statement deal exactly with how I could substantiate the reasoning behind my action.
Yes, thank you.
And I don't want to transgress the redaction by saying anything further, but I am satisfied, as far as I can be, that that action mitigated the decision for John Dines to skip bail.
And would officers in the line of command above you, including Daxo S. Phelan, have been aware of...
Sorry, I missed that.
Would officers in the line of command above you, including Mr. Phelan, have been aware of that rationale and those decisions at the time?
Mr. Phelan certainly would have been, because this was a case that taxed us severely. These cases are not dealt with as routine. They're dealt with on the basis, again, coming back to the point, what is the SDS doing, what's the purpose of it, and what are the risks attached to each of its actions at any time, including the actions of the undercover officers.
You stated that you would personally supervise the necessary action to protect John Dines from legal repercussions.
And
was that the cancelling
that's exactly
of the warrant?
what I did in respect of the redacted issue.
Got it. In your inquiry witness statement, you confirm you discussed your approach with DAC Maynell and
Yes.
say that it was an appropriate and principled approach to an intractable problem.
Yes.
What principle, without again revealing anything under the redaction at the moment, to what principle were you referring there?
Well, the principle was the greater evil would for John Dines to have appeared before the court. So the principle was accepting and acknowledging that whatever decision we took on that was going to, in some sense, transgress and almost go against the Home Office guidance. Again, we had to make a decision. In decision-making as Commander Ops, there are a number of times when we are on the boundaries of the law, particularly dealing with SDS activity, and we did it with honesty, commitment and integrity. And if I got it wrong, I got it wrong. But I don't think on this occasion I did.
Was the intractable problem that you were referring to there the arrest of John Dines and his charge with a serious criminal offence in his cover identity? Yes. Wasn't there an option to reveal to the court, the prosecution, and indeed the investigating police team, the fact that he was a UCO?
There was an option and there is a consideration, and if it had been normal undercover policing in respect of usual crime as opposed to this extraordinary version of undercover policing that we had, that's what happens. You normally inform the court and the court makes a decision as to whether or not it progresses, and the prosecuting authority makes a decision as to whether they pull the case. In essence, what I was doing was short-circuiting that and pulled the case. Now, I accept in the strict letter of the law that shouldn't apply.
Yes, and you would accept, I'm sure today, that it's again doesn't follow the Home Office guidance and
Yes.
it does mislead
Well, I've
the
already
court.
said that.
Yeah. Should well, was any and should any consideration have been given to the subject of a disciplinary investigation of John Dines in relation to this incident?
I'm not sure it wasn't, actually. I can't remember exactly the after effects of John Dines disappearing. No, I mean, given those circumstances now, today, yes, that would have been part of the decision-making process. But it's difficult to acquiesce and or direct an officer not to attend court and bail
HN4's cover driving licence was formally endorsed, but his real licence was not, although his real licence was confiscated from him by you. Isn't the fact that his real licence didn't accurately reflect his true driving record problematic?
Yes.
But again, that was just something to weigh in the balance.
Well,
of
it
what
was part of the consideration, yes. The fact that he didn't have his licence for a year was in fact carrying out the punishment, but I agree, his own licence didn't get endorsed.
There was a disciplinary investigation and subsequent disciplinary action was discussed by you in a minute to Daxo S. Phelan, and you stated that there is always a residual risk that if HN4 was to lose his job, that he might turn against us with all the associated dangers that entails, and you proposed making proper representations to AXO on his behalf. Subsequent to that, Peter Phelan persuaded John Howley and the Assistant Commissioner that no disciplinary charge needed to be preferred. Is that your understanding?
Yes, I think it involved the very senior officers, not just within the branch, but outside of the branch and management services, I think. And there was a lot of heartrending over that as to whether or not, what action should we take.
And that's an example of the prioritisation
Yes.
of operational security and secrecy over
Yes.
disciplining this type of behaviour.
Yes.
And again, you accept that that's problematic, but it was the decision that was taken at the time.
Yes.
You say in your inquiry statement, just finally on this, that you considered your actions to be principled and a pragmatic example of handling this particular offence, where the officer wasn't arrested with others, and you don't consider that the court was misled in this instance. Do you still consider that to be your view, that it was principled and pragmatic?
We're still talking about HN4?
Yes.
Yes, I do. The danger of that particular case being becoming public in respect of the undercover officer was, in my mind, one of the principal reasons that we took the decision, but it wasn't taken lightly.
Thank you. I'd like to move on then, please, to the targeting of the particular fields and deployments in your era as Commander Ops. The types of groups and fields of activism that were targeted during your tenure as Commander Ops are set out in each of the annual reports for the period of time when you were in that post. And you've already told the inquiry that you would have seen those annual reports at the time, is that right?
Yes.
So you would have been aware of the general fields of deployment and the names of the groups that were being targeted at the time.
Correct.
In respect of justification, there would have been reasons that the MPS as an organisation thought a particular field and a particular group was justified in being targeted, but there would also have been influence from the security service, is that
Absolutely right?
You say you weren't routinely in receipt of SDS reporting. Do you mean by that the intelligence reports themselves?
Correct.
You say that if there was anything inappropriate about it, you would expect that to have been dealt with at Detective Chief Superintendent level at the very highest, is that right?
Yes.
You were, though, as you've accepted, aware of the groups and the general fields of
Broadly, yes.
Targeting from the annual reports. I take it that you didn't consider there to be anything unjustified or inappropriate about the targeting of the groups listed there.
No, and I didn't consider that it was necessary for Commander Ops to be involved in that layer of decision making unless there was contest and concern about the particular target, in which case that would be referred to me.
Thank you. I've just been asked to pause, sir, so that you can read the restriction order, please.
publication made of information stated today between 2:45 and 36 seconds and 2:45 and 45 seconds.
Thank you, sir. If you had thought at the time that targeting of a particular group wasn't justified, what action would you have taken as Commander Operations?
Well, I would have sought advice and information to justify why the decision was taken. As I say, at my level, the details of each target were not necessarily known to me, but the Chief Superintendent and his team on Esquad were experienced Special Branch officers, and they would be the ones that make the decision on targeting, as you say, with the cooperation, understanding and direction in some cases. No, direction is too strong a word. Advice of the security service on the targets, and I would only be consulted, I would be consulted if there was a real concern about whether or not such targeting was appropriate.
And I take it that, to your recollection at least, there was never anything raised with you by those underneath you at Detective Chief Superintendent level that such influence that the security service were having over targeting was problematic or inappropriate?
Yeah, it is not that I can recall.
What was your experience of the Home Office's influence over the SDS and targeting of groups and individuals in particular?
Well, the Home Office would be party to the general national intelligence picture from the National Security Committee. Home Office were members of that, Special Branch, the Security Service, military. So the overall threat to the country, specifically, would be part of Home Office role. Coming down a level to specific targeting of extremism, in other words, political extremism, etc., the Home Office would not necessarily have a role in operational matters of that nature at all. But if there was concern politically about activity that was threatening the state, then of course Home Office would have the opportunity to put that to the police. But it doesn't mean necessarily that they decided the targets. It just means their advice was such that, well, they didn't decide targets at all. Their advice was taken into account. And
was there a degree of deference by Metropolitan Police Special Branch to that sort of influence from the Home Office?
No, I don't accept that at all.
In your witness statement to Operation Hearn at page 7, it's tab 2 of the bundle, MPS 0723255, you said that the Home Office and Prime Minister were aware of the SDS and were very conscious of the difficult and stressful work undertaken. How did you come to that understanding, that they were aware of the SDS in particular?
On the 9th of June 1988, or was it the 6th of June, I can't remember, but it was June 1988. Margaret Thatcher was discussing with her Principal Private Secretary, Robin Butler, about the threat posed to this country by animal extremists. Margaret Thatcher was glowing in her praise as to how the police were dealing with the threat by animal extremists. Margaret Thatcher then offered a suggestion to Robin Butler, had the police considered undercover operations. Happily, we were able to tell the Home Office, who were also involved in the tripartite chat, that we've been doing it for 25 years. And actually, thank you very much for your support. That is why, at Prime Minister level, at government level, they knew, and you didn't have to be at Prime Minister level, because the threat to the street, to the fur trade, to the calf trade, all sorts of things, was indicative of the need for some form of intelligence to combat a threat.
And the Prime Minister and indeed the Home Office were keen to try to use undercover deployments
Yes.
to penetrate
Well,
those groups.
I read Margaret Thatcher's enthusiastic praise as being a tick in the right box.
Thank you. In looking at, again, the memorandum written by DCI Docker in relation to his review of the SDS following the Scott affair, which we know you saw at the time, it indicates that final decisions regarding targeting rested with the Chief Superintendent of S-Squad in consultation with the Commander Operations,
Yes.
namely you.
Correct.
And HN 115 Detective Chief Superintendent Tony Waite also recalls that he thinks you would have been consulted and effectively authorised decisions on targeting.
That's not unfair.
In your inquiry witness statement, though, you say that as far as you can recall, you were rarely, if ever, required to intervene regarding SDS targeting decisions. By intervene, do you mean make those targeting decisions and authorise them in the first place?
Yes.
Or do you mean interfere or intervene
Well,
if there was something wrong?
I would intervene if my judgment wanted to be satisfied that the targeting was correct. But I had confidence in my senior officers that they would make that judgment. I can't recall ever querying the justification behind a potential target. For that. It's quite possible it happened, but I can't recall it.
Oughtn't you to have been more involved than it seems you recollect being in targeting decisions and the justification for targeting particular groups, given what that review by Mr. Docker said, and given Tony Waite's recollection that you were more involved in authorising targeting decisions?
Well, I can't recall, but if they say that, I've no reason to oppose it, but it was certainly not as a matter of cause and a matter of practice. It would be exceptional.
You say that you agree that the factors set out in the SDS annual report for 1989 to 90, and the reference is MPS 0730905 at paragraph 8, page 7, it's tab 37 of the bundle, were the most pertinent when it came to targeting decisions, and those were the degree of involvement and control of public order activity exercised by a political organisation in its widest sense, its past general behaviour at public order events, and the coverage already given to it by the SDS and other special branch sources. Is that right?
Yes, I mean, the issue of public order and SDS targeting of issues affecting public order is important. As I've mentioned before, the febrile atmosphere in the country in the 70s, well, certainly after the Vietnam riots, 70s and 80s, was quite intense. Public order was a major problem, and it went on until the 1990s, after it was suggested the SDS should have been shut down. The welling public order problems justified, in my mind, entirely the fact that we needed to have extraordinary measures to deal with extraordinary problems. And that's what happened. It also applies to areas where we have been criticised, and in fact were criticised in the opening remarks of the Commissioners' Council, that social justice campaigns should not have been targeted. I agree in principle they shouldn't have been targeted, and they weren't targeted. It was the extremist groups and agitators around those justice campaigns that were targeted, and there is a misunderstanding that we targeted the justice campaign itself. We did not.
You also refer to the covering letter accompanying the 1984 Home Office guidelines on the work of Special Branch. The reference is UCPI 4584, paragraph 5, and it's at tab 31, sir, of your bundle. Senior officers must exercise strict control over the selection of targets for investigation when the current activities of an organisation are legitimate and peaceful. And that paragraph relates to assistance to the security service, and particularly about collecting information about subversive or potentially subversive organisations or individuals. And you say that the context for this was clearly mainstream inquiries rather than undercover intelligence operations. That's paragraph 102 of your statement. How did you come to that understanding?
Well, I think it's fair to assume that in the developing operational concerns we had in terms of gathering intelligence, and don't forget it was James Callaghan, the Home Secretary in 1968, that demanded the Commissioner got his act together in intelligence gathering. We weren't doing this for our own benefit. We were doing it on behalf of the safety and security of the state. So when we have an organisation that is potentially a threat to public order, and there's a plethora of reasons why that may be, not necessarily at the time, but the build-up to subversion as it was, and indeed subversion who it may be today. And as I mentioned, Jonathan Hall's advice that there should be a statutory provision for subversion. I think that's a recognition by the intelligence coordinator, Jonathan Hall, that the threat from subversion today is not dissimilar to the threat from subversion when we were facing it in the 70s and 80s. So what appeared on the face of targeting may not always have been the complete rationale for gathering intelligence on that group.
But specifically with this this requirement applying in the context only of mainstream inquiries and not undercover operations, why shouldn't this requirement apply to undercover intelligence operations and the SDS?
I'm not sure whether Home Office fully understood at that time exactly the operations of the SDS. Undercover policing, and I have to say the terms of reference for this inquiry talk about undercover policing in the general, whereas basically it's about the specific of the SDS and the NPOIU. And all I would say in respect of those matters is we targeted what we felt was necessary. The SDS was a complete new range of activity, and I don't think that has been completely and fully understood. And it's not for me to say, it may not have been understood at the time the Home Office made those guidelines, the extraordinary activity that the SDS was involved in. I don't think that was fully understood.
But the guidelines themselves don't expressly exclude undercover intelligence operations on their face, do they?
Yes.
And indeed, paragraph 6 of that letter says special branch investigations into subversive activities in particularly sensitive fields, for example, in educational establishments, in trade unions,
Sure.
in industry and among racial minorities, must be conducted with particular care so as to avoid any suggestion that special branches are investigating matters involving the legitimate expression of views. Now that applies to SDS undercover deployments, doesn't it?
And they were.
And there were deployments by the SDS into some of those particularly sensitive fields, weren't there?
Yes.
If we look at paragraph 8, it says it is not the function of the force special branch to investigate individuals and groups merely because their policies are unpalatable, or because they are highly critical of the police, or because they want to transform the present system of police accountability. Isn't there the need for senior officers to exercise control and oversight of the selection of targets, all the more pressing in sensitive undercover intelligence operations?
I agree, and we did.
Because
and I agree with paragraph 8's sentiments entirely.
Thank you. Because there's a risk of interference with lawful activity, isn't there, in those circumstances? Was that risk recognised at the time?
Yes, it could do.
And there was a risk of interference with civil and political liberties, weren't there?
Well, sometimes there's a thin line drawn between protest legal and protest illegal and public order problems, and it's not always possible to delineate exactly where the line is. But yeah, I agree with the sentiment.
And there's also, in those circumstances, a particular risk of collateral intrusion,
Yes.
isn't there? And that's what you were alluding to a moment ago.
And collateral damage was a real issue for us, because there's no doubt the nature of the SDS activities increased the possibility of collateral damage.
And what kind of consideration was given to that collateral damage or collateral intrusion by you and senior officers at the time in relation to targeting?
It would be considered by the squad, and again, if it was considered necessary, it would be referred to Commander Ops.
And how was a UCO to determine what was collateral but was nonetheless of potential intelligence interest? What guidance were they given about where that line is drawn?
This again, and it's been a recurring theme in this inquiry so far, doesn't entirely understand intelligence gathering as it was in those days. What appears to be, as it's been remarked many times on SDS reporting, why do you need to report that? What's it to do with the colour of our eyes? What's this, that? Each scrap of intelligence and information needs to be brought together, assessed, collated. All intelligence is information, but all information is not intelligence. And the process for dealing with intelligence, in gathering scraps of information that go together and form a jigsaw, a puzzle that comes together maybe much later than the apparent information that's been offered, is something which I think has not been understood as an assumption that intelligence gathering only involves, and should have only involved, pure intelligence. Well, it's not. It's about information that is converted to intelligence by an assessment made by others, and that's the back office. The officers and the squad, they had their experience in special branch to go on, but they did not make the decision as to whether the information they were reporting was intelligence or information that need to be assessed.
I want to just ask you briefly about the police accountability report that was on political extremism and the campaign for police accountability within the MPD Special Branch of January 1983. The reference is MPS 0748355. It's at tab 85 of your bundle, sir. Upon becoming Commander of Operations in 1988, were you aware of this report at the time?
I must have been, but I can't say now. Yes, I must have been.
At page 5, paragraph 1.1, there are concerns reported there that the extreme left wing were attempting to secure ultimate control over the MPS and the advancement of known extremists. Do you recognise the concern set out there?
Yes, I do.
During your time?
It's an example of where politics becomes merged with extremist activity. There is no right of police to interfere with genuine political activity, as said in the previous paragraph. But where that genuine activity crosses the border, that political activity, into disorder, disarray, and subversion, as it was in those days, then the police have a responsibility to deal with those matters. And just because at that time there was a considerable amount of activity against the police, and there was a desire by the left-wing extremists for police control, either through police committees or local councils, it's not surprising that some disorder arose out of that activity. And where that disorder arose, we needed intelligence to cover police activity on it, and that's exactly what we did.
And were you familiar with the unofficial accountability groups, independent bodies whose sole function would be to watch and report upon the work of the MPS, and that they were of interest to Special Branch because of the nature of them wanting to watch and report on MPS activity?
I think I understood the question, and if I did, yes.
Okay. Did thinking of that kind, set out in the report there, influence UCO deployments in the SDS or their reporting at the time you were Commander of Operations, so far as you understood?
Yes.
And was there interest in certain groups and fields simply because those groups were known to be notoriously anti-police, such as the Troops Out movement?
As I've tried to explain, Mr. Simcock, it wasn't about anti-police feeling. I mean, we're used to that. We've had generations of that. The police are the whipping boy for a lot of activity. We take that as part of the course. That's not what this was about. It's where public order, disorder, and other activities threatening the safety and well-being of the state were brought in for political means. Then we had a duty to gather intelligence on that, to inform our uniformed colleagues and others in combating it.
Were you aware of action taken by any action taken by the SDS in terms of targeting police accountability groups in order to give central support to district commanders to counter the efforts of those police monitoring groups during your tenure?
I can't recall that, no.
What assistance were you aware that Special Branch provided to counter the efforts of police monitoring groups during your time?
Well, I can assume, and I know from my period as a Chief Superintendent in Ruislip, that there were community groups assembled in each county and borough area which dealt with all sorts of matters, including the role of the police. So at that level, there was, and a Chief Superintendent on divisions, there was a level of supervision and involvement in police matters. Going up to the national level, that's when it comes into A8, public order and or special branch, then we would be involved, or the SDS would have been involved, where there was intelligence or a need for intelligence on the threat to public order. Not because somebody was objecting and criticising the police.
Were you aware of the establishment of a support unit within A7 to collate and disseminate within the force information relating to the activities of those involved in the police monitoring group? And
No.
And so you didn't have any involvement
No.
with them? So would you characterise intelligence gathering and reporting on police monitoring or police accountability groups as a matter of collateral intrusion, or were they specifically targeted?
No, it would be a core responsibility if it justified the action, and justifying the action means they were a threat to public order.
And it was that threat to public order which justified targeting, not the fact that they were anti-police?
Potentially, yes.
What do you mean potentially?
Well, yes.
Were you aware at the time of a concern by the Home Office about the expansion of Metropolitan Police Special Branch's remit with regards to the police monitoring groups, along the lines of intruding upon those where they were merely trying to hold police accountable?
Special Branch, the Metropolitan Police Special Branch, from my existence in it from 1965, were well aware of the need to keep within the rules of the game as far as special branches were concerned, the Home Office guidance. I don't remember specifically any changes to that, but there were at least 2 other instructions, I think, from the Home Office on the role of the special branch, and we concurred with those. We complied with them.
Were you aware whether this police accountability report was updated during your time as Commander Operations?
By the police or by the Home Office?
Either.
I think the Home Office updated it, yes. I think there was an inspection, I wasn't in London then, I was in Cambridgeshire, but I believe there was an inspection carried out by Her Majesty's Inspector of Constabulary into special branches, and as a result of that there would have been, no doubt, recommendations and corrections or updating.
Were the security service during your time as Commander Operations interested in the activities of the police monitoring groups or not?
Not that I was aware of.
Were you aware of their decision in March 1988 that they weren't interested in receiving intelligence on police accountability groups from MPSB, as such groups were not considered to be subversive?
Well, I've tried to explain that in previous answers. They may not have been overtly subversive in the definition strictly as it should, which is why the security service stood back from public order problems. But a more pragmatic view of these issues by Special Branch and by our uniformed colleagues indicated there was still a need to go for intelligence on areas which were a threat to public order. And if that included police policing groups, police monitoring groups, so be it.
And so it was that threat to public order that fulfilled a proper policing purpose of any targeting of those groups?
Well, public order at one end, subversion at the other.
Thank you. Sir, I'm conscious of the time. I still have some more questions, but it may be time for a break.
Well, let's ask those who are most affected. Mr. Gunn, would you like a break now?
Not particularly.
How about our shorthand writers? Okay, how much longer can you go on for without a break?
15 minutes?
Yes, that's fine.
Fine.
So thank you. I'll carry on. I just wanted to make sure that those who might need a break had one if they wanted one. I want to move on to social justice and defence campaigns, which you've mentioned briefly beforehand. You say at paragraph 116, page 47 of your inquiry witness statement, in relation to these type of campaigns, that a targeting decision had to fulfil either the policing requirement of preserving the Queen's peace or supporting the security service in its counter-subversion task, as you referred to a moment ago in relation to police monitoring groups. What safeguards were there to ensure then that particular care was taken by Special Branch that they weren't investigating and reporting on the legitimate expression of views, as opposed to fulfilling a proper policing purpose?
Well, I reiterate what I said about social justice campaigns. We did not target social justice campaigns. Whatever has come out in evidence to this inquiry so far, the policy from Special Branch was not to target the social justice campaign itself. What we experienced were, and anybody that lived through the 70s and 80s will remember, the disorder created by extremist groups and individuals that latched on to justice campaigns to further their own political or extremist cause was significant. So it's those people we targeted, and it's those people that were the subject of SDS activity, not the social justice campaign itself.
But what consideration was given then to safeguarding against collateral intrusion into those social justice and defence campaigns?
Well, the operational directions and the nous of the individuals that were undertaking this work understood that there were boundaries that they had to stay within. Sometimes they may have strayed outside. Obviously they did from some of the details presented to this inquiry, but they understood their role, and it was, as far as possible, dealing with extremism, subversion, and those issues, not social justice.
What about racial justice campaigns?
Well, the same.
So what was the Metropolitan Police's attitude towards those type of campaigns when you were Commander Operations, that they weren't targeted specifically insofar as they were reported on, it was collateral intrusion due to a risk of extremists taking over or influencing those campaigns?
I can only speak for my period when it was my watch between 88 and 91. I do not recall any specific targeting of racial groups per se, but there may well have been, and there obviously were, intrusions into intelligence gathering of those areas where there was a threat to public order by extremist activity. And that was not necessarily involving the racial organisation itself. It was the fringe groups and individuals that latched on to those organisations, to those campaigns.
And during your time as Commander Operations, what was your awareness of the nature and extent of racial or racist violence in London at the time?
Well, sadly, I think racial violence existed from way back. We've only got to look at the record of Brixton and et cetera, racial violence was endemic within society. As far as we were concerned, we were tasked as Special Branch to provide intelligence to our uniformed colleagues, to the security service, to others, to deal with extremism in whatever form it reared. And if it was racial issues, then it was against those that we targeted.
And did you have an awareness of criticisms by ethnic minority communities, police monitoring groups and justice campaigns of an inadequate response by the MPS to racist violence? Were you aware of that during your time as Commander
Well, I don't think
Operations?
you could not be aware of it sitting where I was seen as Commander Ops.
And what steps did you take to address those concerns and criticisms?
I would reiterate with the Chief Superintendent and the teams to tell the troops when they were being at meetings, advised on the areas where they go, and importantly areas where they don't go. So there were personal briefings from the team in the back office to the frontline officers, and they would then use their own initiative as to when that may have happened or not.
And I think you've given your view on this, but just so I check that my understanding is correct, you would say that a high incidence of racially motivated crime was understood to represent a particular public order risk during the time you were Commander Operations, and that was likely to make policing more difficult and potentially more dangerous.
Both for our uniformed colleagues, yes.
And so it was in clearly everyone's interest to address those concerns.
And I think the Welling demonstration in '91 illustrated that amply, because there was a racial influence for the anti-racist league in there and the bookshop, where there was mayhem, absolute mayhem.
In relation to the MPS, the Metropolitan Police Service as an organisation itself, I want to ask you just a few questions about racism in that context. In relation to the MPS as an organisation and your tenure as Commander of Operations, what was your experience of racism within the organisation itself and its officers?
The Special Branch or the Metropolitan Police? Both.
Primarily Special Branch, but both.
I joined the Metropolitan Police in 1963. I joined Special Branch in 1965. In all my career in Special Branch and or before at uniform, and indeed as Chief Superintendent Ruislip, I was obviously conscious that it was a threat that the police needed to deal with sensitively, properly, but firmly. But I never saw any overt racial activity within Special Branch or in the surrounds that I was working with at Ruislip or whatever. That's not to say there wasn't some, because clearly there was. But I didn't witness it, I didn't see it, and I would have been appalled if that had motivated our actions.
I think you knew HN 593 Detective Chief Superintendent Bob Potter
Yes, I
during
did.
your time. Does the same comment apply to him, that you didn't witness or hear about any racist behaviour or comments by him?
Well, let me put that in context. Bob Potter was seriously ill. I saved him from jumping in front of a tube at St James's Park as part of his illness. What he did, his behaviour was unacceptable, totally unacceptable, and he knew it, and we knew it. But the man was ill and ultimately was put to a secure hospital and died of his problems. And I will not accept Bob Potter being used as a thrust to demonstrate that there was racial activity in Special Branch just because one man who was seriously unwell did what he did, which was an outrageous behaviour, if I remember it rightly.
I understand. Did you know HN 86, who's a closed officer and a DI in the SDS? Did you know?
Sorry, HN?
86. If you don't know who that is, we can give you the cipher list. Again, so please don't use his name.
Yes, I did know.
Did you ever witness or were you ever aware of any racist behaviour by him?
No. And to put that in context, I believe he was at the end of my period at Commander Ops. I can't be absolutely sure. I don't recall having much to do with that person.
Okay.
Obviously, I have listened to the evidence
Yes.
presented to this inquiry. I'm surprised. I'm saddened by the current impasse. But having said that, I don't personally see any racial activity or discrimination by that person.
Thank you. Were you ever aware of family liaison officers assigned to bereaved families of the victims of racist violence, reporting on them and their justice campaigns?
No.
Or that their reports were shared with the SDS and Special Branch?
No.
What would you have done if you'd become aware of such reporting at the time?
Well, I would have made a judgment on the veracity of the comment, whether or not it affected our role as Special Branch, and dealt with it accordingly. I mean, it's hypothetical now to say something that happened 20, 30, 40 years ago. What would I have done about it? I don't know.
Would such a practice have been justifiable, and if so, on what basis?
No.
Thank you. I want to ask you very briefly about elected politicians and reporting
Yes.
upon some of them during your time. What was your understanding, briefly, as to the nature and extent of targeting of elected politicians during the time you were Commander Operations?
Well, it was the same with the man on the street. Elected politicians have a right and duty to represent their constituents and express their own opinion. And some of those opinions, as you well know, in the 70s and 80s in particular, were pretty extreme by some members of Parliament and by local authority chiefs. So be it. That wasn't our role. What we did become involved in, and it was possibly collateral damage, as you described it, information or intelligence that came to the SDS that a particular member of Parliament or whatever was involved in something that came within the definition of either public order problems, subversion, or something untoward. Then, where the safety or security of the state may have been threatened, whatever the person's status as an elected representative, they still had a responsibility to comply with the law. And the police had a responsibility to report where there was potential threat to the law. And some of the comments made by some of those people at that time, as you well know, were on the borderline of stirring unrest.
Were you aware at the time between 1988 and 91 of intelligence reports on Mr. Ken Livingstone while he was an MP?
Well, I knew about Ken Livingstone, yes, and I knew his politics, but I wasn't aware of any wrongful intrusion in his activities, no.
You weren't aware of intelligence reports by the SDS on him attending and speaking at various meetings?
When was this?
Primarily in 1988, but through that period.
No, I was new to Special Branch Commander then, but that's not an excuse. No, I didn't know. I mean, it's not impossible that I would have been made aware of that because of who he was. But he did espouse some extreme views at times, didn't he?
And so would you have regarded reporting upon him as justified at the time?
Only if it threatened public order or was subversive. And I keep repeating, we did not and should not have interfered with the genuine political activity of members of Parliament or elected members of councils.
Was reporting on left-wing politicians influenced by the security service at the time, so far as you're aware?
Not from my point of view, but you better ask them that.
And were you aware whether the Home Office, Prime Minister or anyone else in government was aware of such reporting of the type on, for example,
I wasn't aware of any intrusion in that level of activity, no.
Thank you. I want to move on to your knowledge and awareness during your time as Commander of Operations of the case which came to be known as McLiable, the court case.
Yes.
But so I'm conscious of the time. This is my last topic. But if
let's finish it and then we'll break for 15 minutes so that any Rule 10 questions can be put to you, and we can then resume.
Yes, thank you, sir. If Mr. Gunn is happy with that, I'm happy to proceed that way. During your tenure as Commander of Operations, what contact was there, so far as you were aware, between Metropolitan Police Special Branch and companies who might be affected by activists' activities, including animal rights activists? What sort of channels of liaison was there between companies and the police?
The McLiable case was interesting from the point of view it was at the start of my it was at the end of my tenure as Commander Ops, I think, where the activity increased, and the civil case. And I spent one evening last week after Dave Morris's evidence reviewing the whole of the McLiable process through the courts here, appeal courts, House of Lords or whatever it was, and the Human Rights Court. And I take my hat off to Helen Steele and Dave Morris for their tenacity, because it took 9 years to solve that case. I can't say, and I didn't see anywhere in a whole evening going through that, there was any mention of me as Commander Ops or of Special Branch per se in terms of SDS in respect of that particular incident. But I can't say it didn't occur. All I can say is I don't recall it.
Did you have any knowledge or awareness at the time of a relationship between Metropolitan Police Special Branch officers and McDonald private investigators in 1990?
No, I didn't have any knowledge of specific arrangements, but let me say this. It was good practice for police in possession of intelligence about threats to industry, commerce and whatever, to share that information with those potentially affected.
Presumably
shops.
Wider than just McDonald's.
Absolutely. McDonald's was just one of a number of organisations. I mean, I recall the Oxford Street Trade Association, where there was firebombs being put around in Oxford Street. It was good practice to inform the industry and the shops that there was a threat. And I stand by that. It was good security practice. It was not, as possibly inferred by Dave, Morris that this was a commercial arrangement. Certainly not. It was good practice in respect of security of those organisations and preventing harm, damage and injury.
Did you know that SDS reporting was being passed to McDonald's at the time?
I didn't.
Did you know that McDonald's had activists, including John Dines, but who they knew was a UCO, followed by private investigators?
I didn't have knowledge of that, no.
In terms of the authorisation of a relationship between Special Branch and private investigators from McDonald's, who would have authorised that relationship and that liaison?
Well, it would have been at a higher level than the back office. It would probably have been at Chief Superintendent level of the squad.
Not at your level?
Sorry? Not
at your level?
Not necessarily, no. It might have been referred to me if there was contention. Libel might have been referred to me because of the ongoing legal process, which took 9 years or 10 years to resolve. But I don't personally recall any involvement with McLibel personally.
And were you aware of, or did you yourself authorise McDonald's private investigators to be told that UCOs were infiltrating London Greenpeace?
No.
We know that did happen. How could that have happened without your knowledge at Commander Operations level?
Well, I don't know because I didn't know it happened.
In relation to the McLibel case itself, in relation to the writ served by McDonald's on the activists, were you aware of them prior to their service?
No, I mean, I got what Dave Morris said the other day and was waving a bit of paper in the air like Chamberlain as if it was damning evidence of something. I'm not sure what that was all about. And certainly, as I've reiterated and do reiterate, the fact that we liaised with commercial organisations was not per se a commercial decision, it was a security decision. It had commercial implications, of course it did.
Why were there security implications to the McLibel defamation trial, though?
Well, I wasn't aware of that.
The MPS made sure that John Dines was not included on the writ of defamation served by McDonald's on activists, including Helen Steele, in September of 1990. Were you aware of that at the time? No. Did you have any involvement in
No, I didn't. And as I said earlier, I only really got concerned with the McLibel trial after hearing Dave Morris the other day. My personal memory of the details of the McLibel incident, that's the leaflet, and the alleged activity afterwards, and then going on for another 9-10 years in the civil case, I did not recall.
Okay. Do you recall ever seeing intelligence reports from John Dines concerning the service of the writ?
No.
Detective Chief Superintendent Waite has said that John Dines' name, he couldn't have been omitted from the writ without a commander's authorisation. Do you have any particular comment on that evidence?
Well, I don't know. I mean, I would have considered the circumstances at the time. It is possible it should have been seen by Commander Ops, but it certainly wasn't seen by me as far as I'm aware.
What consideration was given, so far as you're aware, to John Dines' risk of compromise on being excluded from...
Sorry, say again?
What consideration are you aware of being given to John Dines' risk of compromise on being excluded from the writ? In other words, that not being included on the writ with other activists, despite his involvement at the time, would have been suspicious to those fellow activists?
I don't recall that decision. I don't relieve myself of the responsibility if it happened, but I don't recall it. but it would have been part of the circumstances in the round, again taking you back to the many answers I've given so far today, in terms of the security of the operation, the interests of justice, the need to protect both the reputation of the Metropolitan Police and the Home Office and government, and they would have been part of the decision-making process involving that particular issue of Dines, but I do not recall it.
Do you recall any awareness of his involvement after service of
No.
the writs, in that he helped activists respond to them?
No.
So you wouldn't be aware of any guidance given to him about what he should
No.
do about that?
I was probably in Cambridgeshire by then.
Was any guidance given to him, so far as you are aware, concerning legal professional privilege implications of his reporting on a defamation case in which his fellow activists were named?
I can't answer that question. I wasn't involved in that, so I don't know the answer, but it would be surprising to me if there wasn't an involvement and advice given to him by a senior officer within the squad.
Thank you. I just have two very short questions on another topic, and it's the topic of true spies,
Yes.
and then I'm finished, sir, with my questions. Are you aware, or do you have any knowledge of who was the first person from the MPS to make contact with the BBC in relation to that programme? And if you're concerned about revealing a name for privacy reasons, if you have a name in mind, you could write it down.
I remember the case well. I've waited 25 years to have an explanation of what went on the True Spies, which was grossly distorted because of the lack of actually what happened as opposed to what people thought happened. I've lost a few friends in the past because they considered my decision was wrong. It may well be with the benefit of hindsight, but I stand by it because the greater evil would have been not to have cooperated with the programme. I got lambasted because insisting all along, as I've done this inquiry today, about the sacrosanct nature of the secret nature of the SDS, and that here you are on television talking about it. Yes, I've no doubt you probably want to ask me about that. The reason was I was approached. Can I mention the name of the senior journalist?
Yes.
I was approached by Peter Taylor, a respected Panorama reporter who I'd worked with in the Special Branch previously on Irish terrorism. Peter had never let me down, and I trusted him. What Peter described to me as Chief Constable of Cambridgeshire and Chairman of ACPO Terrorist Committee made my jaw drop. I was terrified at what he was telling me, and it was clear he had been well briefed by somebody connected with the SDS, either past or present. Clear. Some of the information that he was passing to me, not just the fact that they were known as the Harries, everybody I think probably knew that by that time, but some of the information of the contacts, the informants, if that had been published, would have done lasting damage, not just to us, but to the government, to the security services, and to us. And I can't emphasise that strongly enough, because it was part of my decision-making process. We either cooperated with Peter Taylor to minimise the damage, or we stood back and let Peter Taylor and his programme do utmost damage possible to the situation that he was describing in True Spies. I came to the conclusion that, and again, the rock and a hard place, I'm afraid, I had to make a decision on what to do. I spoke, can I mention the Assistant Commissioner of Specialist Operations? Yes. David Vaness?
Yes, you can.
I contacted, can I mention the Commissioner, John Stevens?
Yes.
I contacted both of those and discussed the case in detail. In fact, I think I actually came down to London to see John Stevens. I went through it in detail, as I'm telling you, that if we didn't cooperate with that programme, all hell would break loose. Not just the end of SDS, but could have brought down the government. It was that serious. My judgment, and I stand by it, was we should limit the damage by cooperating with Peter Taylor. And I go back to what I said earlier. I trusted Peter Taylor. He was obviously insisting on editorial control, and I understood that. So I knew we couldn't influence the programme unduly. But we did influence the programme, and we did manage to take out of that programme the very damaging matters that would have been involved if we hadn't, would have been spoken if we hadn't been involved. Now, having said all of that, it was again a judgment we had to make.
We know that there was a meeting over lunch between the BBC and Roger Pierce and Colin Black of the Metropolitan Police. Were you aware of that meeting at the time?
No, my role as ACPO TAM was not to interfere with the Metropolitan Police activities, and although I would have been party from the Terrorist Committee, and so was the Home Office because they were members of the Terrorist Committee, and so were the security services, although I would have been party to that, I do not recall Roger Pierce or Colin Black? Colin Black's meeting, and I don't recall, but I believe Roger Pierce sent a note round to former SDS officers warning them that they might be approached. Roger got crucified by others, not fully understanding what that was all about. But having said that, I wasn't aware of that. Peter Taylor asked me if I would contact former members of the SDS to see whether or not they would cooperate with the programme, and I said absolutely not, and I didn't.
Do you know...
But there were two members on that programme that went off-piste. One was a special branch officer, and that's sad that he went off-piste, and one, I believe, was a West Midlands officer, and they said things off-script that were potentially damaging, and of course increased the criticism of that programme. And the true story behind True Spies has never been published.
My original question was, do you know who first made contact?
No.
From
the Met.
From the Met to
No.
BBC?
No, the first person to be approached was probably me when Peter Taylor contacted me in Cambridgeshire and explained what he proposed to do, to my horror.
Thank you. Thank you, sir. Those are all my questions.
Well, now we will break for 15 minutes. Can I express the hope, please, that Mr. Gunn can be finished by 4:30, which is the time that I think he has been promised?
Yes, we will make every effort, sir.
Yep.
All rise.
Yes.
Thank you, sir. Mr. Gunn, we're nearly finished.
Okay.
I just have a few more questions as a result of the Rule 10 process, and they're on a variety of different topics, but I shouldn't detain you very long.
Okay.
Firstly, then, in relation to the McLiable court
Yes.
case, the defamation case, did you know Sid Nicholson or Terry Carroll at all?
No. Did I know?
Did you know Sid Nicholson
No.
or Terry
No,
Carroll?
I've read from the papers that they are former police officers who work for McDonald, but I didn't know them either.
You didn't
I
know
wasn't
them at
aware
all?
of their position as former police officers or whatever. Didn't know them.
And you didn't have any involvement with
No,
them in the McLiable
Definitely
case?
not.
In relation to the Debenhams case, you were aware at the time of Bob Lambert's involvement in that case, that court case.
Yes.
You said that you weren't involved in disclosure decisions
No.
or those decisions in the court case, the prosecution of Clark and Shepherd. Is that
Correct.
still right? You've also given evidence, though, primarily in relation to John Dines, but in general as well, that it was your decision what, who to and when to disclose information to the courts about an undercover police officer's involvement in the
Yes.
arrests of people. And you were aware of Bob Lambert's involvement in this particular prosecution.
I was aware that he was monitoring the extremist activity of animal extremists, yes.
But in particular in relation to that Debenhams incident, the incendiary
I'm aware
attacks.
from reading the paper, I can't say at the time that I was totally, can remember it now, but I'm aware from the paperwork of his close involvement in those matters, yes.
So why?
Intelligence gathering, I hasten to add.
So why weren't you, given your acceptance today in relation to the general position and in relation to the Dines cases, why wasn't it you making those decisions about disclosure within those prosecutions? Why weren't you more involved as Commander Operations?
Because there's a demarcation line between intelligence and evidence. Intelligence is the role of the special branch. Evidence was the role of the anti-terrorist branch. And there is a corridor of air between the two so that intelligence can be protected and the propriety of the evidence given in a criminal trial is not jeopardised by intelligence issues.
I see, thank you. You mentioned relatively briefly, but in passing, in relation to animal rights extremist activity, during your time as Chief Constable of Cambridgeshire Police, that you were aware of targeting of STAC, Shack, Stop Huntington Animal Cruelty. Were you aware that SDS officers were targeting them at the time?
I wasn't aware at the time because I was in Cambridgeshire, but I would have been amazed if they weren't, because we had enormous problems in Cambridgeshire with the Huntington Life Sciences premises, enormous public order, potential serious damage and threatening the community, as I mentioned earlier. So yes, I was aware of the activities, and I assumed that there would be SDS involvement in the intelligence gathering area of those events.
I see, thank you. In relation to the disciplinary case of HN 155, and if you wish to remind yourself of who that is, the cipher list will be provided to you. It
Please.
was the officer who was disciplined and was ill health retired before the Scutt case.
Sorry, yes, I do. I do
Number
remember.
155.
Here we are. Yes.
And don't mention his name, but you're aware of that case. HN 155 wrote a letter directly to the commissioner at the time by way of complaint
Yes.
about his treatment in his disciplinary case.
Yes.
in which, by his own admission, he was very close to members of the Socialist Workers' Party and on close terms with some MPs in the left wing. That letter, as I said, goes directly to the Commissioner, and you were made aware of it in a minute at the time. You then wrote to Daxo, Peter Phelan, saying he may raise this if he remains unhappy with the Home Secretary. Why would there be a concern about HN 155, or indeed any UCO, raising a concern about a disciplinary matter with the Home Secretary?
I don't think it was specifically about the individual, it was about the circumstances of the incident. In other words, any publicity of the 155 case, and that would have happened in a disciplinary inquiry, would have been public. If that became public, then the whole issue of the role of the SDS would have been exposed. So it wasn't, I think, specifically about the individual, it was about the circumstances that the Home Office would need to have known if there was a reputational issue coming their way, and there would have been a reputational issue, as I've explained.
Thank you. Mr. Buchanan, who succeeded you as Commander Operations, gave an interview with Operation Hearn in common with yourself. He referred in that interview and his statement to briefings being given to the Home Office on the SDS. Do you recall that during your time as Commander of Operations?
Was party to a briefing, can I mention he's dead, a senior Home Office official?
Could you write them
write
down?
It down. Would you write it down to start with, and then we'll...
It's in my statement.
If it's in your statement, then yes, you can.
Yeah, it's in my statement. I was party to a conversation at the Home Office with John Chilcott, who was a senior Home Office official. We briefed, I can't remember the exact timing, I think it was late on, just before I went to Cambridgeshire. There was an issue of part funding. I'm sure that conversation involved updating John Chilcott on the activities, and although I can't specifically remember it, I'd be surprised if we didn't mention at that time 155 case if it was considered to be of reputational importance, which it was.
So were, to your recollection, briefings to the Home Office about SDS activities issue related rather than routine and regular?
I'm just trying to think how many times I went to the Home Office, and it can't be more than 2 or 3. But I do specifically remember the meeting with John Chilcott, and I think I went with Peter Phelan as well, 2 of us. Because the SDS was an operational police unit, and because it was part funded by the Home Office, there was a Home Office interest.
Yes.
And I have to say also, as I've said repeatedly today, the sensitivity of the work of the SDS was considerable.
Yes, thank you.
Political damage that could have been done by exposure of the work was ever present.
Mr. Buchanan's Operation Hearn interviewer noted in his interview with him that Mr. Buchanan had said that both he and you stood up to the Home Office and were therefore not popular with them.
I noticed that, and I have to say again, and I repeat, I have grave concerns about the use of notes, not even signed, and a statement of an officer which appeared in the public domain through this inquiry. I think is outrageous.
Do you have any comment on the accuracy of that?
I have no comment at all.
if, a separate topic, if you had become aware of a particular deceitful sexual relationship between an undercover officer and a member of the public during your time as Commander of Operations, would you have taken any steps to inform the woman in that relationship of the fact of that person was a UCO?
That's a difficult question. It would be a hypothetical answer at best. I can't think that would have been what we'd have done. But it depends, or would have depended on the circumstances. It would have depended on the extent of the relationship, the seriousness of the relationship.
Whether there was a child?
Whether any children were involved, yes, of course. And I don't wish to minimise the behaviour of those officers that went off piste, but there is a difference between a sexual encounter, which happens when men and women get together in the circumstances that we put our officers in, and a long-term affair. Both of them shouldn't happen because they were wrong, but they did. And I think as far as the circumstances of informing the women, I watched the ITV programme of 3 of the women and it tugged the heartstrings, because clearly those women were hurt by the arrangements. But they did appear to be a longer-standing relationship. They weren't just casual sexual relationships, and they certainly weren't, from the information I know I've got, directed or intended to seduce the woman into giving target evidence.
Are you aware of the Commissioner's position currently that the women should have been told if there had been any discovery of such a relationship?
I was going to raise this matter at the end of this questioning, but as you've raised it, I'll mention it now. The Commissioner's statement at the end of last Monday, I thought was sad and unnecessary, and not in any sense denigrating his rightful say of apologising to all and sundry. That was right, and I join his apology in that. What the Commissioner didn't say, and this is grievous in respect of the truth, of the other side to this story, the other part of the story, all those officers that put their lives on the line for in the interests of the state, has not been discovered. And for the Commissioner to say that the SDS was a dysfunctional unit, carte blanche, for 40 years, when we know the Home Office funded it for 25, we know the security services and the Home Office were complicit in most of what they did, I think is an appalling stretch of the truth. And I fear that damning statement that it was a dysfunctional unit is grossly unfair. And there are a lot of people that have contacted me from the undercover officers who feel grievously hurt that their reputations have been traduced and besmirched by, sadly, a Commissioner giving half a story. I know Mark Rowley, he's a very fair and reasonable man, but he didn't, sadly, use the whole or inform the whole story. He threw us all under the bus for the sake of 8 or 9 miscreants. That's unfair.
Thank you. Separate topic. Do you recall reading any paperwork reporting on what was known as the Lucasade incident in November 1991 that was mentioned in the True Spies documentary?
Sorry, I didn't catch that. Say again.
Do you recall reading any paperwork about reporting on what was known as the Lucasade incident in 1991?
No, I don't.
Thank you. Last few questions on the subject of the Wayne Cadogan. last few questions I have for you, Mr. Gunn, are on the subject of the Wayne Cadogan, John Dines false identity.
Right.
Were you aware at the time that that identity was based on a deceased child's identity?
Not directly, but I would probably have assumed it was because of the timing of Dime's involvement.
Thank you. When John Dines was arrested, his driving licence in that name was seized and kept during his time in custody and recorded on his custody record. Do you agree that having had a driving licence in a second unauthorised false identity demonstrated a degree of planning and anticipation of use of that identity, and it wasn't just a spur of the moment giving of a name upon his arrest?
Well, I agree with what you said. Tactics used by undercover officers, particularly in those far-off days, did vary. It was wrong, but I keep coming back to the fact the essence of undercover policing is deceit, deception and subterfuge. And the tactics that go with that in terms of operational, at the coalface police activity necessarily mean that some tactics aren't quite as comfortable in the cold light of this room. And I have to say also, when judging those matters, we didn't get it all right, but we neither got it all wrong.
Thank you. Thank you, sir. Those are all my questions.
Thank you. Any re-examination, Mr. Sanders?
Hopefully that's worked, sir.
Yes.
Only to ask Mr. Gunn if there was anything else he wanted to cover or add before completing his evidence.
No, I think I've had a fair say. I don't think there's anything more that can add any gravitas to what I've said.
Thank you. Thank you for spending the whole of what has been quite a long day giving evidence. I hope it has done you no harm. Your evidence has certainly been informative, instructive and interesting.
Thank you very much.
We are going to adjourn now until Thursday, when we will start at 9 o'clock in the morning to accommodate 2 witnesses, so we can finish them comfortably in the time available.
Thank you, sir. All rise.